Thanks. Thank you, Thanks, Dan, very much for the invite and for allowing us to help your group get informed on prompt payment as we approach the August deadline. We do welcome questions. We are accumulating questions from the series of webinars that we're doing across the industry, and we want to share the questions and the answers with the different groups in the industry. So we'll provide those to Dan, and he'll be able to circulate those as well. Today we're going to cover a lot of material, so it could be overwhelming. You will have the slide deck to refer to, and any questions that come up, please feel free to channel them through Dan to us, and we'll be pleased to try to answer them if we can. Today we're going to cover an introduction to the Act itself. We're going to talk about prompt payment, talk about the impact and effect and changes to the Builders Lien Act. We're going to talk about adjudication, the transitionary provisions in the Act, and then lastly, getting ready. We're going to invite questions as we pause after each section, so please feel free to ask the questions at that time. If not, we'll ask at the end. We'll answer them at the end of the session, but we would invite you to ask questions during the presentation so the dialogue can be, we think, a little more engaging. So I'll start off. First slide, then, Jordan. The new Prompt Payment and Construction Lien Act is really a renaming of the current Builders Lien Act, but it introduces three real important concepts. One is prompt payment, one is changes to the existing Builders Lien Act, and the last one adds a fast track adjudication dispute resolution process that is intended to help the parties address disputes during the life of the performance of the contract itself. The purpose overall of the legislation is to provide consistency and speed up payment throughout the construction industry. And as I said, provide an alternative to the courts so the parties can resolve disputes in relation to a payment issue under the contract or subcontract during the life of the project. The legislation comes into effect in late August, as Dan has mentioned. We've been involved in this issue since about 2013, so we're pretty aware of what the government's been thinking, what the legislation says, and some of the things you need to do to get ready through our involvement as well in the Ontario legislation that's been in place for 2 years. And we now have the working experience from Ontario. Our primary goal today is help you understand what's coming and how to get ready for it. So again, we welcome any questions and we'll do our best to try to answer them. The Act applies to anybody who is performing work, providing services, furnishing goods and materials with respect to an improvement in land. The existing Builders Lien Act is based on the same concept, and that is carried over into the prompt payment legislation. So we're familiar, most of us would be familiar with what constitutes an improvement. The sectors that are affected are broad. They include small, home builders to large oil and gas projects, regardless of the delivery model that's being used. Although you will see that the legislation has really been put together for the traditional construction method with an owner, a general contractor, and subcontractors and suppliers. So there will have to be some adaptation if the project delivery model or method is different than that traditional and standard form. It impacts and involves owners, developers, consultants, and architects and engineers are expressly included in the legislation. Again, as long as they're providing services with respect to an improvement. It also captures municipal, county, and regional authorities, including P3s that those entities are involved in. There are some parties, entities that are not subject to the legislation. Obviously, federal government is not because it's provincial legislation. And unlike Ontario, where the provincial government is included in the legislation, provincial government in Alberta is not, and the existing Public Works Act will continue to govern any claims you might have or payment problems you might have with respect to provincial government. P3s involving the provincial government are excluded, and the operation and maintenance portions of any P3s are excluded regardless of who they're with. So really the concept of an improvement is fundamental to the prompt payment legislation. And again, that's a carryover from the Builders Lien Act. So those are similarities. An improvement means anything constructed, erected, built, placed, etc. Fairly broad definition. And the Alberta courts have added to that definition by including such things as design, planning, permitting if used, renovation, demolition, reclamation, etc. The Act applies to your contract whether it's written or oral, as long as you have an agreement to furnish work, services, goods, and materials furnished to an improvement in land. So Tom and Jordan are going to talk about the most important part of this legislation, which are the new prompt payment provisions.
Thanks so much, Gary. So, first thing that we want to emphasize when we discuss prompt payment is that while payment may be intended to be prompt, it does not guarantee payment, right? This is not a silver bullet. It does not guarantee that you're going to get paid for your work. This means that you still need to do the same risk analyses that you've already done before. It also means that you need to avail yourself of your builder's lien remedies or your labor and material payment bonds if those become necessary in order to obtain payment. But with that, we'll look at the prompt payment cycle itself. So the owner has 28 days under the new legislation to pay the contractor after receiving the contractor's proper invoice. And that meaning of the term proper invoice is important, and we'll get to it later. But he has 28 days to pay. Once the contractor receives that payment, he has 7 days to pay his subcontractors. And then once those subcontractors receive payment from the contractor, they have 7 days to pay their subcontractors. So we can see this more easily in the next slide, which is a diagram. And it shows how the funds ought to flow down the construction chain. So here we see the owner has his 28 days from the proper invoice date to pay. The contractor then has 7 days to pay subcontractors, which means they should receive payment within 35 days of the proper invoice, and subs within 42 days of that proper invoice. This is vastly quicker than existing payment timelines, which can be many months without any payment at all. So I've spoken about the term proper invoice. Let's go into that in more detail. So a proper invoice must be issued by the contractor to the owner, and it must include some specific information that the legislation requires. This includes a description of the work or services performed or the goods supplied, the amount due or owing, and the information identifying the authority under which the work or services were performed. So these are the legislative minimums. The owner is entitled to add additional requirements in the prime contract, so long as those additional requirements don't contradict the requirements of the legislation. Now, importantly, a proper invoice should state that it is intended to be a proper invoice. If it doesn't, then it doesn't count. So what this opens the window to is draft invoices, which are invoices that do not state that they are proper invoices. And these can be sent to the owner in order to discuss the contents of the invoice without inadvertently triggering the prompt payment timelines. So these requirements only apply to the contractor's invoice to the owner. However, we anticipate that contractors are going to contractually require their subcontractors to issue their invoices in a similar format to the proper invoice with the same kinds of information. So I've told you about what a proper invoice is. The next important facet is how frequently it should be issued. The answer in the new legislation is that it has to be issued by the contractor to the owner every 31 days. This is a mandatory period. It can be shortened by agreement, but it cannot be extended. Now, that being said, the legislation is silent on the issues of milestone, phased, lump sum, or annual progress payments. So what this means is that it is possible to comply with the legislation while still having, for example, milestone payments. What you can do as a contractor is issue invoices that are proper invoices for nominal values. And then when it comes time to, for example, invoice for a particular phase of completion, then you can issue your proper invoice again for that particular phased component. Now, we've said that the proper invoice must be issued every 31 days. Now, the legislation doesn't itself penalize the contractor if he fails to issue the proper invoice every 31 days. However, He may face adjudications or disputes from subcontractors whom want to be paid every 31 days. And he also may run afoul of the legislative requirements and face rejection by the owner should he fail to comply with the mandatory 31-day time period. Now, because the timeline of the proper invoice is so crucial to the prompt payment regime, others on the construction chain need to know when that proper invoice is issued, and the new legislation provides an answer. So a subcontractor who is required to make payments can demand that the contractor confirm as soon as possible the date that the contractor gave the proper invoice to the owner. This will allow those subcontractors to figure out precisely the prompt payment timeline that applies. Now, I've spoken about the 31-day time period. I want to pause briefly to discuss what we mean by days. So timelines in the Builders Lien Act and now in the prompt payment legislation are expressed in days. Now, this isn't working days, this isn't calendar days. This means that every single day counts. These timelines also apply to the notices of non-payment and notices of dispute that we'll get to later in the presentation. Now, under the legislation, deadlines that fall on a Sunday or on a holiday will carry over until the following day that is not a holiday. But that means that the deadline can still fall on a Saturday. So what we suggest is that it's always prudent to avoid waiting until the last day to, for example, send your proper invoice and to send it earlier in the week if possible. Now, we make this point because certain adjudication timelines in the regulations are instead expressed as calendar days. Calendar days are different in that they also exclude Saturdays as well as Sundays and statutory holidays. So it will be important to understand which process you are in, and that in particular for certain adjudications, Saturdays will be excluded as a potential day. So there are some unacceptable preconditions to the rendering of a proper invoice. However, approval or certification by the owner cannot be one of these preconditions to the rendering of a proper invoice. For example, what this means is that the owner can't say that until the value of work has been certified, the contractor cannot provide a proper invoice for it. So this has some implications. The owner has 14 days from receiving the contractor's proper invoice to object to paying some or all of that proper invoice. And he has to do so by issuing a notice of dispute that we'll get to later in the presentation. But as a consequence of this 14-day time period, it means that if the owner does have a cost consultant, that cost consultant needs to review and certify the value of the work within that 14-day time period. And if they miss that time period, then the owner will have to pay the complete proper invoice, even though the complete proper invoice may exceed the value of that certificate. So this is going to put a considerable strain upon your cost consultants or your architects or whomever is validating the work in order to comply with that 14-day timeline. Now, limited pay when paid is permitted by the legislation, but it still has to comply with the requirements of the legislation. In particular, you still need to send the payments when they are in fact received within the legislative timeframes, and you need to provide the proper notices of dispute or notices of non-payment under the legislation. Now, I mentioned some unacceptable preconditions. There are, however, some acceptable preconditions to the rendering of a proper invoice. Importantly, commissioning and testing of an improvement or the work or services performed can be a precondition to the rendering of a proper invoice, so long as it is stated in the contract. So what this means, for example, is that an owner can say that until concrete passes the required strength test, the contractor cannot issue a proper invoice for it. And because the contractor can't issue a proper invoice for it, he can't get paid for it. So this is the power of this commissioning and testing precondition to the rendering of a proper invoice. The legislation will also entitle the owner to, for example, require statutory declarations and WCB clearances as typical preconditions for a proper invoice, and we suspect that that won't be an issue and that the legislation will allow that. Lastly, we note that set-off is still allowed down the construction chain. So this means that if a proper invoice is rendered to the owner, but the owner believes that there is a set-off, for example, for deficiencies owed against that proper invoice, he is entitled to claim that set-off. However, he has to do so very explicitly within the notice of non-payment. So I'll turn it over to Jordan, who's going to speak more to what happens if there are notices of non-payment.
Thanks, Tom, and good morning, everyone. I'm going to take you through this next section here dealing with events of non-payment. This is one of the more complicated sections that we go through. So if you have any questions throughout, feel free to throw them in the chat. We'll do our best to get to them at the end of this section. But I think in order to really navigate this section, one of the things that we found most helpful is looking at it in terms of the forms. So this section in the regulations, it outlines 5 forms. It's got forms 1 through 5, which sort of deal with various notices of disputes, depending where the dispute is originating from. So let's look at it in a chart form, since I think that might be the easiest way to consider this notion. So always at the top, we start with the owner. The owner effectively has 2 choices when they get the proper invoice. They can either pay the proper invoice or they can dispute all or part of the invoice. Now, let's start with the notion of them disputing all or part of the proper invoice once they've received it. They have to do this, as Tom said, in 14 days. And if on or before that 14th day, they have an issue with the proper invoice, whether that be from certification, reviewing the invoice, whatever it may be, that is going to where they do not want to pay all or a part of that invoice, they have to issue this Form 1 owner's notice of dispute. And again, you have to do it within 14 days. Now, the owner is going to issue that down to the contractor. The contractor, having received a Form 1, is going to have to issue themselves a Form 2. Form 2 is the contractor's notice of non-payment. And what the contractor is doing is saying, hey, my subcontractor, I got a notice of non-payment from the owner, meaning I'm not going to get paid. What that means is you're not going to get paid. So they're going to issue a Form 2, and they have to do that within 7 days of getting a Form 1. We'll talk a little bit more about all these forms, of course, but the next way is that we're going to fall down the chain. So the contractor has issued a Form 2 down to its subcontractor, and the subcontractor itself, if they have a sub, needs to let their sub know, and they're going to do that with a Form 4. And they're going to do that within 7 days of receiving a Form 2. Now, that's sort of the left side of our chart here. Let's look at the right side of our chart. So this is where the owner does pay. Now, if the owner pays the contractor in full for the proper invoice, the contractor may, in some instances, send that money directly down to the subcontractor. And if they do, there's no forms. The money's going directly down. But if the contractor has an issue with their subcontractor, even though they've been paid in full, the contractor can issue a Form 3. And this is a contractor's notice of non-payment dispute. And they have to issue this 35 days after issuing of a proper invoice. Why 35 days? Where does that come from? Well, it's the 28 days for payment and then 7 days thereafter. So at that point, they have to issue a Form 3. So this is where a contractor is taking issue with some or all of a subcontractor's invoice. It can be one, it can be a portion of one subcontractor, or it can be all subcontractor invoices. But either way, the parties that they're taking issue is who they're sending a Form 3 to. Now, if the contractor, let's follow sort of that chain down. If the contractor issues a Form 3 to their subcontractor, the subcontractor is going to have to issue a similar to the other instance where the subcontractor is saying, hey, I'm not getting paid. They need to tell their sub, they're going to issue a Form 4. Okay, they'll issue the Form 4. They're going to issue it in the same sort of notion, and they're going to do it 7 days after receiving a Form 3. Now, if the contractor pays the subcontractor in full, the subcontractor themselves, just like the contractor, has the ability to tell one of their subs, hey, you're not going to get paid for all or a part of your invoice. And in that instance, they're going to use Form 5. Okay, so effectively, it's the same thing as a Form 1, Form 3, and Form 5. It's just who's sending it. Form 2 and Form 4 are sort of notices saying, hey, I've received one of these notices, and I'm letting you further down the chain know what's happening. So we'll talk a little bit more about these forms, but I think that's the easiest way to think about it and to sort of logically look at these forms when I talk about them. So let's deal with Form 1, starting right at the top. This is the owner's notice of dispute, and they're going to have to provide it in writing to the contractor within 14 days. So that's a key timeline right there, that they're intending not to pay all or a portion of the invoice. The tricks with this form is you have to use Form 1, and you have to give the full particulars for the reason of non-payment. You can't simply say, hey, I don't want to pay. I couldn't certify in time. I don't know. Maybe it's payable, maybe it's not, so I'm just not going to pay. No, that will not fly. You're going to have to give full particulars for the reason of the non-payment. Now, as part of this, if there is a holdback that's occurring, the holdback is not part of the non-payment. Okay, that's still a statutory holdback. We don't need to touch that. So Form 2. So we have a Form 1 going from the owner down to the contractor. Contractor is going to issue a Form 2 down to its subcontractor. So this is coming directly from the contractor. They're going to have to issue this within 7 days. And they're going to have to use Form 2. Okay. In these cases, you all have to use the forms as they're outdated, as they're provided for in the regulations. Now, the interesting thing about Form 2 is this particular requirement, which requires that the contractor must undertake to refer the dispute with the owner to an adjudication within 21 days of giving a notice of non-payment to its subcontractor. So what that means is, if you issue a Form 2, you're a contractor because you have a dispute, you've received a Form 1, you must undertake to send the dispute to an adjudication. It triggers the adjudication process. And what that means is the subcontractor is getting sort of that comfort, so they can sleep at night knowing that the dispute up above is going to be worked in the adjudication process and will follow the adjudication timelines. So it's this sort of positive or mandatory or step that you must take in order, in the instance of a Form 2, because you as the contractor are undertaking to do that. So Form 3, we're now on the other side. Okay, this is a contractor non-payment to one of its subcontractors. So this is, you're issuing this form notwithstanding that the contractor has been paid in full by the owner. This is because the contractor has a dispute with one of their subcontractors. Have to issue it within 35 days, and you have to use Form 3. Just like Form 1, you have to provide the full particulars for the reason of the non-payment. Okay, I don't like your invoice. Your invoice doesn't make sense. Whatever it may be, it needs to be the full particulars, everything you're setting out, because this is going to get referred to an adjudication. And one of the key things about an adjudication is that you set out exactly the issue, because it's all done by written submissions. We'll talk about that a little bit later, but it really is quite critical that you're giving all of the information you can as part of this notice. Now, the other thing that's noteworthy and Tom talked about, but I want to highlight again, is if you fail to issue this notice, the Form 3 or the Form 1 or the Form 5, within the required timeline, you become obligated to pay. So if the owner doesn't issue a Form 1 within 14 days, they become obligated to pay. If the contractor does not issue a Form 3 to its subcontractor within 35 days, they become obligated to pay their subcontractor the full amount of the invoice, whether there's a dispute or not, because they didn't issue the Form 3 in time. So Form 4 kind of exists on both sides. And Form 4 is where we have a contractor non-payment to a subcontractor. And this is where the subcontractor is letting their subcontractors know, hey, we've got a dispute, we're not getting paid, and you have to send this out in 7 days, and it must be in Form 4. Just like Form 2, the contractor or the subcontractor has to undertake to refer the dispute with the contractor to an adjudication within 21 days. So you can see how there's a Form 1, there will be a Form 2, that will trigger a Form 4, and there could actually be 2 disputes happening at the same time as it relates to the same amount. It certainly is possible. And the legislation has contemplated that and how things could be consolidated in order to deal with them in a streamlined fashion. Carrie, did you have anything you wanted to add?
No.
Okay. So Form 5, this is sort of on the other side here. This is where we have a subcontractor having an issue with one of its subcontractors. So somewhat like Form 1, somewhat like Form 3, this is Form 5. And the notion of this one is where the subcontractor, they've been paid in full, but they have an issue with their own subcontractor. So they're going to have to issue this within 42 days of the contractor issuing the proper invoice. It's got to set out the full particulars, just like Form 1 and 3. And again, if they do not provide this notice within the 42-day timeline, they become obligated to pay their subcontractors in full. So if you're taking any issue or you're going to take an issue with an invoice, you really have to watch these timelines, because if you fail to follow the timeline, the monies will become payable in full. So what happens when there's a partial payment? Okay. We talked about and I think it's worth highlighting that if you're taking an issue with the invoice, or the owner takes an issue with the invoice and it's one line of the invoice, it's not the entirety of the invoice. If it's only one line, the rest of the invoice is still payable. It's only that one line that they've taken issue with that's not payable. So that would make it a partial payment, right? Because they've taken issue with one of the line of the invoice, they've issued a Form 1. So now what do? We have to figure out, okay, how do we deal with this partial payment? If you can figure out as the contractor, because that's where the obligations sit, and if you can figure that out, which subcontractor it applies to, that subcontractor would not be paid for that amount on sort of a pro rata basis. Now, if you can't figure out which subcontractor these amounts apply to, or these non-payments apply to, you're going to do it across the board to all of the subcontractors on a pro rata basis. So it's a bit of a onus on the contractor to figure it out. And we have the same instance if the contractor is not paying the subcontractor in full and they have their subs underneath, the subcontractors are going to have that same sort of obligations of payment and figuring out what happens if there's a partial payment. Now, again, any amounts, whether they're coming down, the owners, contractors, or subcontractors, they have to pay all the amounts that are not the subject matter of a notice of dispute or notice of non-payment. So if you're not receiving a notice of non-payment and you're the contractor, within 14 days, you are entitled to full payment on the 28th day. So let's look at this in a chart. I think this is one of these charts that you may want to, when we send out the slide presentation, you may want to go find, print out, and put on your wall to start off with, because this is sort of the process and how it's supposed to work and the timing of it. And I think it's really helpful to think about it this way at first until you really get a handle on it. So we start on the left, which is 31 days from the submission of the last invoice. And this is when the contractor is going to submit the proper invoice. Okay, and this will trigger the submission of the proper invoice is going to trigger all the prompt payment provisions. 14 days from the submission of that proper invoice, so we've now advanced 14 days, this is the deadline for the owner to issue a notice of dispute as it relates to all or a portion of that invoice. 21 days from the submission of the last invoice, of the proper invoice, is the deadline for the contractor to issue a notice of non-payment to its subcontractors if there was a notice of dispute issued by the owner. 28 days from the submission of the proper invoice, this is when the owner is going to pay in full the amount of the proper invoice or any undisputed portion of the proper invoice. 35 days from the submission of the proper invoice, the contractor is going to remit full payment or partial payment to its subcontractors. And then 42 days after that, the subcontractor is going to remit full or partial payment to its subcontractors. Now, down at the bottom there, there's still things that are happening at the same time, because in that 14-day window where we have the deadline for the owner to issue a notice of dispute, the consultant is going to be working to review the work and certify payment within that 14-day window. Now, if the owner does issue a Form 1, there is still the opportunity before day 28 for the parties to sort of work it out. And so there's a 14-day window where the parties can sort of resolve any potential issue maybe that they have with a Form 1 before it gets referred to an adjudication. And that way, on day 28, they can still be paid in full, whether that full or the undisputed portion of the invoice. So is there any questions with respect to payment? I don't see any questions in the chat here.
I have a couple here, Jordan.
Great.
Can you clarify that the contractor needs to always provide an invoice, even a nil invoice, if a gap exists between months when work has been completed? If this is not done, what are the implications to the contractor when they next issue an invoice with a value greater than nil?
Tom, did you want to take that one? I know that was in your section.
Sure. So excellent question. There are certainly construction projects where there will be a winter shutdown or a spring thaw or pauses in the work such that work isn't going on every single month. The legislation doesn't really contemplate this and doesn't consider it. It just has a flat rule that says every 31 days you have to issue your proper invoice. So in circumstances where no work is going on, technically, according to the legislation, the contractor should be issuing a nil invoice every 31 days. That being said, because the legislation doesn't penalize the contractor for failing to do so, in all likelihood, if the contractor doesn't submit a nil invoice, there will be no repercussions anyway, because subcontractors will also have no money to be seeking from the contractor. So I suspect that this is an oversight in the legislation that in practice won't cause too many problems.
And
then
I don't think the legislation contemplates an invoice needing to be issued if there's no work to invoice for. So it may be that if there's gaps in the performance of work, then you don't have to issue an invoice because there is no work being performed. Now, as Thomas said, it doesn't say that. It says every 31 days for work performed. So it may be that the safe route is to issue that nil invoice to comply with the 31-day period. But if you're not doing work, I can't see how you could have a problem not issuing an invoice until you actually have work to be invoiced.
And then, thank you. And then with regard to the new rules for non-payment, is there a greater onus on the contractor to provide a statutory declaration attached to an owner invoice to now need to be more explicit in terms of whether there have been delays in payments to subcontractors?
Yeah, I think I would see that as a separate issue. The stat deck or the requirements for a stat deck in my mind don't change at all. I don't know what you think, Tom or Jordan, but my thinking is it would remain as is. There certainly is the requirements to pay. So the stat deck, there might be some additional wording in a stat deck saying that you've actually complied with the requirements of the prompt payment legislation. We might see that added into the current wording of the stat decks. I can anticipate that. What do you think, Tom or Jordan?
One of the aspects of, for example, if the contractor is paid in full by the owner but still disputes that a subcontractor is owed money, there will be a dispute there. But because the form for the notice of non-payment from contractor to subcontractor isn't given to the owner may not be privy to the fact that there is a dispute underneath. So it's conceivable that, yes, owners will require greater detail in the stat decks received from the contractor to divulge that there are, in fact, disputes with subcontractors. And so the owner, for example, may say that we want to know anytime a Form 3 is issued by contractor to subcontractor, and that should be memorialized in the stat deck.
And I
so
think
that certainly could happen, I think.
And that's going to be a contractual requirement. That's not a legislated requirement. So, practically speaking, the legislation isn't speaking to that. Your contract and what is required as part of the contract in a stat deck is where that's going to be put. And I think that's what Carrie was. I'm just reiterating Carrie on that point.
That's an excellent question. We're definitely going to add that one into the FAQs. Whoever asked that, thank you, because it's a very good question.
Yeah, and we've got one that sort of follows from Peter here, I see in the chat, and he sort of asks, what is the, what happens if a Form 3 is issued unfairly? Who values this disputed amount with respect to Form 3? And so I think, Peter, I'm glad you asked that question, because you're sort of saying, well, if Form 3 has an issue and we don't think it's fair, what happens? Well, Form 3 is going to get adjudicated, is maybe the easiest answer to that, because of the way it flows down. And Form 4 will be triggered with a Form 3 and will then have the dispute sent to an adjudication. So if there is an issue of sort of anything in the Form 3 or, an unfair cutback or whatever it may be, and if it results in an unpayment, it will go to an adjudication. And we'll talk about adjudication a little bit later in the presentation.
And there is, as Jordan will explain, the adjudicator can determine that the dispute is vexatious or without merit quite quickly. So if the subcontractor is abusing the dispute process by issuing a Form 3 unfairly, or just to be a problem, a nuisance, or leverage, then the adjudicator can dismiss the claim and award costs. So, and Jordan's going to get into that in the adjudication portion.
Dan, did you have any other questions?
No, that was it from, we just had another one pop up, Jordan.
Yeah, I see one here from Scott. So Scott asks, we are a supplier of construction materials and equipment. I wonder if we can consider ourselves as a subcontractor when we sell to a contractor. The contractor does not necessarily specify that their purchase is for a certain project.
Well, interesting is that, and Tom, you're the builder's lien guy that you're going to talk about, but you wouldn't have a lien right if you didn't if you don't know which lands the materials are improving, but you may not, and Tom, I'd be interested in what you think about this. You may not have a right under prompt payment as well, as you don't know what land it's improving. But I think you would be bound by the prompt payment legislation in any effect. Suppliers are considered subcontractors; they're included in that definition. So, what do you guys think, Tom, Jordan?
Yes, I think that if the contractor is performing an improvement, then your supply of materials and equipment falls under the Prompt Payment Act, and so prompt payment will apply to you, and technically builder's lien should apply to you as well. Your difficulty is that you don't know which project that you are supplying equipment to, which doesn't necessarily affect your prompt payment rights, but will make it more difficult for you to register your builder's lien because you don't know which plot of land to register it upon. So what you may want to do is avail yourself of your rights to information under the Builders Lien Act that we'll get to later on in the slide deck that allow you to essentially figure out where your equipment is going, who the owner is, and terms of the contract between the owner and the contractor.
Exactly.
And that'll help you identify where your equipment's going.
Yeah, Tom is bang on.
Another great question. That's another great question. Thank you.
Yeah, this legislation has a couple sort of new wrinkles that actually make it easier in this instance. If you are that supplier of construction materials and equipment, you have an ability to sort of get in there and get some of the information that you need to figure out where these materials are being supplied. That lets you avail yourself of more remedies. And I totally agree with Tom too, that all the prompt payment provisions are going to apply, whether you know where the materials are going or not, because you're going to issue an invoice up, and really you'll have to know for the payment notions when the contractor is sending that to the owner. That will be another piece that'll be interesting in order to trigger all the prompt payment provisions. Any other questions, or we'll with that, I guess we'll move to section B. If anyone has any questions, feel free to throw them in. We'll get to them at any point sort of during the presentation. The more questions, the better. We're always happy to answer them. So Tom, why don't you take it away on section B then?
Thanks so much. So I'm going to discuss builder's liens. So first question, can we still register builder's liens? The answer is yes. So your ability to register a builder's lien is not affected by the new prompt payment legislation. You can still register a builder's lien whenever you have performed work for which you have not yet been paid. And that applies even if you are presently within an adjudication process. And as with the current legislation, parties still cannot contract out of or release or waive their builder's lien rights. So what has changed are some of the timelines. So in general, the timeline has changed for registering a builder's lien from 45 to 60 days. There are two exceptions. The first exception is presently in the Builders Lien Act, and it is for oil and gas wells. They get 90 days to register their builder's lien. The one that's added, and this is important, is that the manufacture and supply of ready-mix concrete, but not the installation of concrete, also gets a 90-day builder's lien period. And this will have some implications that we'll shortly discuss. The holdback requirement is still present in the prompt payment legislation. What this means is that the owner still has to withhold 10% of the value of the work from the contractor. This hasn't changed. Similarly, the holdback requirement between contractor and subcontractor has always been a matter of the subcontract, and that remains in the present legislation as well. However, there are some impacts in the new legislation to holdback release. So one is that concrete suppliers who now have a 90-day lien period can expect that their holdback is going to be held for longer, i.e. 90 days instead of 60 days, on account of the fact that they have 90 days to register their builder's liens. The other implication of the prompt payment legislation is the new requirement that for projects over $10 million that last over a year, the owner must release the accrued holdback to the contractor every year. Now, this is the only requirement in the legislation. It's open to owner and contractor to agree to more beneficial arrangements for progressively releasing the holdback. But this particular requirement is that if your contract's over $10 million, the holdback must be released annually. Now that considers holdback release between contractor and owner. So the holdback can also be progressively released between contractor and subcontractor, but that is a matter for the subcontract. So for most subcontractors, in light of the 60-day builder's lien period, they're going to get their holdback after 60 days. And again, for concrete suppliers, as well as those working on oil and gas well sites, they're instead going to have to wait 90 days for their holdback to be progressively released. And importantly, if the contractor is agreeing to progressively release his holdback to subs, he is going to want to ensure that there are mirroring provisions in his prime contract that allow him to also obtain his holdback progressively from the owner. There are also some changes to substantial performance. So the concept is still the same. What has changed is how the certificate of substantial performance is posted. So in the present Builder's Lien Act, it has to be posted to the job site so that everyone can see it. Now this is the default under the new legislation, except if the contract allows electronic posting of the certificate of substantial performance. If it does, then you can post it electronically instead of posting it to the job site. Now, other jurisdictions require the certificate to be published in an industry publication or to have the certificate sent to all of the other parties involved in the project. Now, that's not the case in Alberta. Alberta's legislation does not elaborate on how the electronic posting should occur. Rather, it's left to the contract. What we expect is for the industry to prepare an online posting hub. For example, they're presently working for BuildWorks, and potentially for some other site, that would allow a central repository for posting of certificates of substantial performance. Now, I mentioned earlier that there are some rights to information under the prompt payment regime. So, parties under a contract can obtain information about the status of invoicing and payment using these expanded rights to information. So specifically, anyone working under the improvement can demand that the parties above them, i.e. the owner or the contractor or the subcontractor, have to provide within 6 days the copies of the prime contract or subcontract as applicable, and a statement of accounts between the contractor and owner or contractor and subcontractor as applicable. So this is a powerful remedy. This allows you to figure out what the terms of the subcontract above you are, what the terms of the prime contract above you are, and what the status of accounts are between, for example, sub and contractor and contractor and owner. And that allows you to see the flow of flow of funds down the construction chain. Now, often at this point we get asked about redacting for commercially sensitive information. What we suspect is that parties who have to divulge, for example, their statement of accounts or their contracts, will be entitled to redact commercially sensitive information, so long as the redactions don't defeat the purpose of the rights to information. So in other words, you won't have to disclose your sensitive financial terms. You'll only have to divulge the rest of your contract that is not sensitive. So I'll pause here for any questions that pertain to the builder's liens or holdback requirements.
I have a quick question. Is there any change to what qualifies as an improvement to the land? Like for us, we custom make an item in our facility, and it may sit here for a few months before it goes to the site, and then it's qualified as an improvement. Does that change at all? Can I by making an improvement in a facility, does that qualify me as an improvement so I can invoice earlier than I normally would?
So there are two aspects to your question. Have the terms of what is an improvement changed? The answer is no, still the same. the second part of your question is equipment that's prefabricated, say off-site, and not yet delivered to site considered an improvement? The answer is no. It needs to be furnished to the improvement in order to be subject, for example, for your builder's lien remedies. So likely what will happen in your circumstances, what should be happening is prompt payment will apply because it's contemplated that your equipment should be delivered to the site, but up until it is delivered, you don't get your builder's lien.
You're muted, Carrie, sorry.
You can still invoice if your contract allows you to invoice for the equipment if it's located off-site. It's just that your rights under the Act are predicated on it being, your builder's lien rights are predicated on the improvement, the materials being incorporated into the improvement. But I still think you're entitled to the prompt payment legislation remedies because you are creating an improvement. And if your contract allows you to invoice before it's incorporated into the works or delivered to the site, then I think you can invoice. Is that a fair comment, Tom, Jordan?
Yeah, well, especially if you're in, the cost of this equipment may be substantial in order for you to build and prepare it, right? So part of your part of that may be a certain amount of payment you want as well. So you have an ability in your subcontract to issue, 50% payment due before a certain time period, or before I start work, whatever it may be. Your contract or subcontract should allow you to do that.
So the only thing it really affects is is your ability to register your lien to protect security if you think you need to.
So David had a question, and he says, with regard to the annual payment of the 10% of the holdback, is the 10 million value inclusive of the value of change orders, or is it just based on the original value?
Tom, you want to answer that one?
I'm presently re-reviewing the form just to make sure, but I don't think the legislation is specific on this. What it says is if the contract value is 10 million or over. So what this would mean is if the value of the contract is changed by change orders to exceed 10 million, then that progressive release of holdback will apply where it didn't before. So I think it isn't premised on the original value, but on how that value was changed.
Yeah, so if you get a revision that brings it over, you were 9.5, now you're 10.2, it becomes applicable. Yeah.
Another interesting question we haven't been asked.
No, that's a good one. Yeah.
Yeah.
All right, I don't see any more questions, so we'll move to adjudication. Again, if you have questions, throw them in the chat. Feel free to speak up. We will do everything we can to get your questions answered. All right, so let's go into adjudication here. Now, adjudication is a new concept as part of this legislation, and it really is this new sort of fast-track dispute resolution process. This is not to be confused with arbitration. This is adjudication. They're different. So adjudication is going to involve the appointment of a certified adjudicator, and they're going to hear a payment dispute between the parties during the performance of the contract. The adjudication process will not involve an oral hearing, sworn affidavits, questioning, or cross-examination of witnesses. The only thing we're going to have is submission of written, written remarks or written submissions and supporting documents. There's no attending in person. And what that means is by just submitting written documents to the arbitrator, to the adjudicator, this can be done very quickly. And we'll look at the timelines on the next slide, but effectively you will go from submitting all of the written submissions to the adjudicator to a written decision by the adjudicator in 30 days. And so this is legislatively mandated, and that's what makes this sort of adjudication process so powerful. It really is sort of quick justice. You're going to get in written submissions on a very specific timeline, and you're going to get a decision that's also very quick. And as part of this, and as part of getting ready, we'll talk about these timelines are going to mean you're going to have to be really, really organized with your project materials. So let's look at those timelines. This is sort of the adjudication timeline broken out. And so we're going to start on the far left, which is day 0. And this is when, we've got a dispute. So you're going to issue a notice of adjudication. You're going to issue it to the other party you're adjudicating and to this nominating authority. We'll talk more about who the nominating authority is, but for now, they're just sort of think of them as the board up above who's going to monitor and deal with the adjudicators. You can agree to a specific adjudicator, but if you can't, the nominating authority, one of their roles is they'll appoint one for you. Once you have an adjudicator appointed or set up, the party who submitted the notice of adjudication is going to have 5 days to provide their written submissions and their supporting documents. The party who receives those documents and receives the notice of adjudication is going to have 12 days to respond by providing their own written submissions and their own supporting documents. That's going to take us sort of the longest way is 28 days. 30 days from that, the adjudicator is going to render the decision day 58. So at that point, you will have an adjudicator's decision. There is the opportunity for a judicial review, or certain steps that you can take with the adjudicator's order if you are not paid, but we'll talk about those in some more slides. So what can be the subject matter of an adjudication? Well, it has to deal with an issue of non-payment. So it can deal with invoicing that's due and owing, but is unpaid. It can be for change orders, whether they're approved or not, and proposed change orders. It can also deal with the release of holdback. Now, if you want to take something to an adjudication that does not deal with non-payment or valuation, you're going to have to get all the parties to agree. And absent all the parties agreeing, you cannot take it to an adjudication. So that sort of means like, well, what can't be sent to adjudication? Well, if it's not a valuation, you can't send it to adjudication. But one of the things that's interesting is if your contract says, listen, if you have a dispute, you're going to have to deal with it through a mediation, through an arbitration or court, you can still avail yourself of adjudication. You just have to go to an adjudication before a court proceeding has been commenced as it relates to those facts in issue, the same issue. And if you get before that, then you can go to an adjudication. It won't prevent you, you're still able to go to court after if the parties are not happy with the solution. That's one of the remedies available to you, but you can avail yourself of this adjudication process, even though your contract may not specifically contemplate it. Now, as Carrie talked about earlier, the adjudicator does have some discretion here. If they feel the matter in dispute is frivolous or vexatious, then the adjudicator can refuse to hear the issue. The other thing that's sort of worth highlighting one more time is that you can only avail yourself of adjudication during the life of the contract. So it has to be during the completion of the contract or subcontract. So how do we initiate an adjudication? Well, you have to provide a formal notice of adjudication to the other party and the applicable nominating authority. Once this notice is sent, the adjudication process becomes mandatory. So adjudications, they're private, they're confidential. Your submissions, your documents that you're providing to the adjudicator, they are not public record. They are not seen by the public. They cannot be searched by the public. However, the adjudicator's order, if it remains unpaid after 30 days, can be filed at court. And once it's filed at court, it becomes part of the public record. And technically speaking, people can go to court, they can do a courthouse search, and they can access this document. It's a bit of a cumbersome process, time consuming and costly, but it is certainly a possibility. So who is the adjudicator and what is the nominating authority? Well, the parties can agree on who will be an adjudicator, but you can't pre-name an adjudicator in your contract or subcontract. You can only pre-name one of the nominating or a nominating authority in your contract or subcontract. The nominating authority, I think it's best to think of the nominating authority as the administrator of the adjudication process. They're sort of up above the adjudicators, and what they'll do is they're going to be responsible for educating, qualifying, and appointing adjudicators where the parties cannot agree to an adjudicator. Now, who are these adjudicators? We're finding one of the requirements that's set out is sort of 10 years of industry experience. So Carrie will talk about it a bit more as it relates to Ontario, but what we're finding is these adjudicators are, sort of industry experts. They're not often, there are some lawyers, but they're not often lawyers. They're often, senior individuals who may be retired or, who are looking, to do some additional work, who have that sort of lots of experience and lots of knowledge. And the advantage is you can look at the nominating authority's rosters and pick one who sort of has experience in the area that you're adjudicating on. You may be familiar with many of the names who are these adjudicators. Carrie, did you want to add a comment about the nominating authorities in Alberta?
We just currently do not have a nominating authority. There's an RFP expected from the provincial government, and we believe there will be two entities. One will be a national-based adjudication, arbitration, mediation society, and the other one will be hopefully a group of associations in the industry who will have on their roster, as you said, Jordan, experienced people who have been in the industry and can understand the issues readily and provide the decisions and the determinations within a very short time period, the 30 days that are required. But we currently do not have a nominating authority. We expect to have two, hopefully. In Ontario, they only have one. And I think with two, we'll have more competition, perhaps better fee rates, and more choices as to who we want to adjudicate the disputes.
Yeah, so with the fee rates, as Carrie's talked about, we'll sort of jump off from there. One of the questions in the slides that we've added to this presentation is, well, who pays for the adjudication? And the answer is it's paid by the parties, and they're going to split it equally unless the adjudicator is ruling otherwise. So the fees are going to be set by the nominating authority. We don't know them yet in Alberta because there are no nominating authorities, but I wanted to give everyone a bit of an example. These are what the fees in Ontario currently are. So there's a flat fee for any adjudication under $50,000. And you can see the adjudicator's fees on the right there. Now, once a dispute gets over $50,000, it becomes an hourly fee for the adjudicator. And a dispute over $1 million, there is a substantial adjudicator's fee at $750 an hour. Of course, the parties are splitting this unless the adjudicator is ruling otherwise. But I thought this is just sort of a notion of where some of these fees may land. So the other thing to think about this, and an important part of the adjudication, is this adjudicator's order, it's interim and binding on the parties involved in the adjudication. And so what that means is it can only be superseded or overruled in a few very sort of narrow circumstances. One of those is if a court order is made in respect of that dispute, the court order will supersede the adjudicator's decision. The other one is if a party applies for judicial review of the adjudicator's determination. We're going to talk a little bit more about judicial review, but it is a very, very, very narrow remedy, and I think we'll have to be careful utilizing it. The other option is if both parties sort of get an adjudicator's decision and they don't like it. Nobody's happy, nobody wants to they think the resolution just isn't great. One of the options available to the parties is they can agree to appoint an arbitrator following the conclusion of the adjudication process. Also, the parties are able to agree in writing to their own resolution of the dispute. So if you don't like the adjudicator's decision, one of the options available to you is judicial review. Now, judicial review is on a very, very specific and narrow grounds, and it can only deal with procedural issues or misconduct of the adjudicator resulting in unfairness. So what that means is just because you don't like the decision, just because the adjudicator didn't consider one of your documents, or you think, misinterpreted a fact, that will not allow you to necessarily advance a claim for judicial review or an application for judicial review. It really is a very narrow grounds. And what we're finding in Ontario is the courts are giving a lot of deference to the adjudicator and their ability to make a decision. So if you are going to go to court and on a judicial review, you better make sure that the facts are very clear and there's sort of some very obvious procedural issue or misconduct that sort of has skewed the result. And one of the interesting remedies is if you do advance this for judicial review, the adjudicator's decision is going to be stayed. But there are significant consequences if you go to court and you are not successful with a judicial review. I would expect that the court would award costs against you. So if you are considering a judicial review of an adjudicator's order, it's something you want to consider very carefully. So what happens at the end of the day if you're the contractor and you've done everything you can? You've gone all the way through the adjudication. You've submitted. You've given the forms. Everything's appropriate, but at the end of the day, you're still not paid. What can you do? Well, you got a couple options. One, after 30 days, you can file it at court, and it becomes essentially the same as a court order. And what that will do for those who are familiar with the process is once you file it and becomes a court order, you get all the available remedies to you to enforce a judgment. So you can get writs of enforcement and all those sort of fun things. The other option is if you have specifically requested it and set it out in your notice and asked it as a remedy from the adjudicator can award you the ability to stop performing the work or services under your subcontract if you've been unpaid. But again, you have to specifically request that, and the adjudicator has to specifically mandate that. And then, and only then, after 30 days, could you stop payment. So it's a very specific remedy, but it just outlines the importance of setting out in your notice and in your submissions what you're seeking. It's a very tight timeline, but you really have to be organized for what you're looking for, not just as a result, but what happens if I get the result I want, if I'm still unpaid. So that's the end of our adjudication section. Are there any comments on adjudication? So I see David sort of has a follow question here. He says, with regard to the annual payment of the 10% retention by the owner for contracts over 10 million, if the owner has regularly paid contractor invoice, is there every expectation that this annual retention should be paid? If not paid, what should the contractor expect to receive from the owner?
The act does contemplate interim releases of holdback. So if this is just in the situations where there is no requirement in the contract for milestone payments or release of the holdback, so that's one exception to it. Tom, I don't know what your thoughts are on the release of holdback. I'd follow up on that question. Tom did correct our answer earlier. Thank you, Tom, to say that the contract value is determined as of the date of entering into the contract and does not include change orders, which the legislation expressly provides. But what do you think of this question, Tom? What's your thinking on it?
I think that the contractor should have every expectation that the holdback invoice pursuant to this legislation would be paid. And the value of that invoice would be the 10% of the value of work that he's performed, i.e. the 10% withheld from all the prior invoices. So if there haven't been any disputes up to that point, then there should be no reason for the owner to withhold the holdback because it's legislatively required. You can imagine there to be issues if, for example, the parties have disagreed about the proper amount of, for example, a proper invoice, in which case the parties may disagree about the value of the holdback to be paid. But just as of conceptually, as of right, the contractor should be paid this holdback invoice pursuant to the legislation.
And if the contractor issues their invoice and it becomes a proper invoice, and if they are not paid, then I think the contractor has all the rights under the prompt payment to issue their form for non-payment. Unless, of course, they receive a Form 1, which the owner is saying, hey, here are the issues that I have. You'll issue a Form 2, and that'll trigger an adjudication on that exact issue. Subject to any other questions, we'll kind of move along through 2 quick sections here, which is dealing with consolidation. It's noteworthy that if, we talked about earlier the notion that there could be multiple disputes on the same issue. If that is the case, you can consolidate the adjudications. The trick is you have to go to the first adjudication, and that adjudicator will make the determination on the consolidation. Tom, did you want to talk about the transition period?
Thanks so much. So we've mentioned this date before, and we'll do it again just to be sure. August 29th, 2022 is your magic date. So any contract or subcontract entered into prior to that date will not be subject to prompt payment, subject to a grandfathering that I'll shortly mention. But all contracts issued or entered into after August 29th, 2022 will be subject to prompt payment. And what we anticipate is that the contract will govern and that the subcontracts will follow the date of the contract. So this will avoid the situation where, for example, the contract was entered into before August 29th and the subcontract entered into afterward. Well, we anticipate that the legislation should be the same for both. However, there is an exception that I mentioned for contracts that are entered into prior to August 29th, 2022. And that is if those contracts are scheduled to remain in effect for at least 2 years, i.e. to August 29th, 2024, then the contract has to be revised to comply with the new legislation by August 29th, 2024. So this gives you a 2-year period to amend your contract if it is entered into prior to August 29th, 2022. Now, importantly, this transition period applies to all of the new provisions. So this includes your prompt payment provisions, extended lien periods, and adjudication as well. So what this means, for example, is that there may be a different builder's lien period applicable to a contract entered into before August 29th, as opposed to one entered into after August 29th. So you are going to want to know when that prime contract is entered into so that you know when your builder's lien period expires.
So this takes us to the getting prepared section, which is an important section about getting ready. So let's dive into this one. And I think, one of the biggest things that the parties are going to need to do is there's a lot to do before August 29th, 2022. And one of the big things that you're going to need to do is to revise your contract documents to reflect the new requirements. So I'm going to, this is going to be my one little pitch is if this is something you need help with, we would absolutely love to help you with it. Just contact any one of us. We'd be happy to sort of walk you through the process, help you with your contracts, whether you're using a CCDC contract or your own main contract. We would be more than happy to help you, make sure that your current contract documents reflect these new requirements. But if it's something you want to navigate yourself or it's something you're thinking about, let's look at what you need to do. So in particular, you're going to need to make sure that your contract document includes all of the requirements for a proper invoice. It also is going to need to make sure that it reflects the timing of invoicing and payment, including what happens if there's a partial payment. If there are any commissioning or testing requirements, you're going to want to make sure that your contract set those out very clearly. What's required? When is it required? Who's required to do it? It's also going to have to look at the mandated timelines for issuing a notice of dispute or notice of non-payment, including where and to whom those notices should be provided. The timeline is very tight, so we want to make sure that our contract is setting out how are we going to be providing these notices? Who's going to receive them? What happens if they're not available? What form of communication can we send them in? Is email acceptable? Does it have to be some other way? And then, of course, your contract's going to have to contemplate what happens if there is a notice of dispute, notice of non-payment, or a notice of adjudication? How will everything continue on the site? How will the billing cycle work? What will it change and who will be affected? So there's even more to be thought about. It's not just as simple as looking at our contract. I think the easiest way to think about this is all of your internal team, project managers, accounting, finance, their roles are going to be affected by this legislation and they need to do certain things to be ready. And, I think you're going to have to look at all of your internal processes. And what are you going to have to look at your internal processes? Well, things we really want to highlight for you, not inclusive, but I think we want to highlight for you is you're going to have to look at your procurement practices, the terms, conditions of tender calls and submissions, your proposals and quotes. Make sure they're aligning to what's now required. Make sure they're setting out and they're following the obligations. If your contracting approaches are not sort of in the traditional, notion that this legislation requires, especially if you're thinking of any alternative delivery method, project management, or even an IPD sort of notion, you're going to have to make sure that your project delivery is going to be able to work within these legislative requirements. And how is it going to work? So your contract's going to have to specifically contemplate that. So we talked about the contract terms and conditions, but of course you'll have to deal with the supplementary conditions, the forms and schedules of all of your contracts, and make sure that those are all properly addressed too. You're going to have to look at the content and the issuing of your invoices. And one of the things we haven't really talked about is the issuing of draft invoices. One of the great things about this legislation, and one of the things that Carrie will talk about in a slide here, is the use of draft invoices to sort of head off any potential issues and only start the prompt payment cycle when the parties are ready to start the prompt payment cycle. And this will sort of help with payment and the timelining to make sure everything's being followed properly. You're going to also have to look at receiving and processing of invoices. We're finding a lot of accounting systems are struggling with partial payment. So how are your accounting systems going to deal with a partial payment, including how are they going to deal with apportioning, a partial payment? And of course, you got to manage your project documents. We'll highlight that one again. But what else you're going to have to do? Well, one of the things we're suggesting is you're going to have to adopt some sort of tracking or tickler system to make sure you are in compliance with all of these mandatory time periods. Simply putting this in iCalendar or on your phone or in a notebook, it's probably going to be very difficult to follow all of the dates, especially if you have more than one project going. So you're going to need to put into these, these tracking systems, the dates for issuance, receipt, processing, and payment of proper invoices. That was that chart that we looked at. You're going to have to put in the date for the certification of work and cash flow requirements. You want to put in the dates for the new holdback and lien periods. And you want to make sure that you're not missing the dates for the notices of dispute and notice of non-payment, including what forms need to be used and when and where they're required. So again, we talked a little bit about the accounting system. Make sure your accounting system is ready and can deal with partially approved proper invoices. How will they be triggered? How will they be followed? Tom talked about the certificates of substantial performance and posting them electronically. If BuildWorks isn't ready and there isn't an electronic database in order to do that, how are you going to do it on your project? Do you have a plan? What will you use? As well, in the event of adjudication, I think it's really important that project documents, they're going to have to be up to date and accessible in a very short period of time. You may have 5 days to get your documents together and draft submissions. And if you're using counsel, you're going to have to get all of those documents to your counsel in a certain amount of time so that they can prepare those submissions. And it's a very, very tight timeline, especially if the matter is complicated and it's not just one invoice or 5 documents. It may be a whole series of documents and photographs and various things. So it will be ensuring that you are keeping your project records and project database really, really organized and concise. So Carrie, did you want to talk a little bit about these slides?
Sure. One of our concerns and one of the experiences in Ontario is that there's a gap between the what the lenders require and the time period in which they're willing to release progress funding or draws, and the obligations under the Act to ensure that payment is made within the specified time periods. So we just highlight this, that you want to align and be aware of what your lending agreements say and require in terms of the time periods, and their certification of the work or their requirement for a third-party certifier to be involved, and the time period that you're obligated under the Act to provide payment. You need to look at that. And we are also seeing in Ontario, in order to address that issue, is the widespread use of draft invoices, as Jordan has described. We think there'll be very little impact on the insurance requirements on projects. We do think that bonding is still a good thing to include, in your project planning. In Ontario, bonding is required under the Act for public projects of a certain value. There is no mention of bonding in the Alberta legislation, but again, we think it's a good idea to include it and consider it with respect to the creditworthiness of the parties you're involved in, their performance and payment and circumstances currently covered by surety bonds, including insolvency. One good thing about prompt payment, I think another good thing about prompt payment is that if there is an insolvency, we think there will be less pain because most parties will be being paid within the required 28 days or 35 days or 42 days, and won't have a 120-day receivable that they're stuck with and have to file a lien or make a claim under the L&M bond. Insolvencies may not be so painful as they've been. Sureties will want to know about how you're addressing the gaps in financing, and they'll also want to know about notices of dispute that have been issued and the results from those adjudication processes. It's not clear yet whether sureties will be bound by the adjudication process because they're not mentioned in the legislation, but one would assume that they would be if they're taking over the position of a defaulting subcontractor or contractor. In Ontario, both public and private sector projects are included, as we've said. Invoicing and payment obligations and time periods are similar. The procurement process in Ontario is included in the transition. So if an RFP is called, that's the magic date for determining whether you're in or out of the legislation. Bonds are, as I said, are mandated on public projects in Ontario, and statutory lien periods are the same for all parties in Ontario. They're different here, as we know. The one thing I'd mention too, with respect to adjudication in Ontario, so far, it's over the first 2 years, there's been 23 adjudications in the first year, and there has been, I believe, 55 in the second year. Most of those adjudications relate to change orders, and also the home construction area seems to be where there's more adjudications than in any other area. Invoicing and payment happens in Ontario, it seems, in a more structured, reliable, consistent basis than it did before the legislation. So our expectation is that here, after some time of adjustment, we will find that payment is more structured and reliable and consistent. And that's really the intention of the Act and our hope that that will happen in the industry here. Use of draft invoices, we've talked about. Adjudication, about 20% of the adjudications referred to an adjudicator in Ontario are settled or have been settled prior to the adjudication being conducted. So just the fact that you need to go to adjudication, I think, is an incentive for the parties to address disputes during the life of the contract itself. And certainly that notice of dispute that's required in 14 days brings forward, what the dispute relates to. And so it's not being kept until the end of the project and then being used as leverage to negotiate a position after the work has been done. As Jordan has emphasized, quick access to your project's records is critical to be able to respond to or initiate an adjudication process.
So this takes us to the last slide of our presentation, which is a bit of a to-do list that we wanted to put together. This might be another one you want to print out, put on your bulletin board, because this is sort of the things, it's not an all-inclusive list, but it's certainly a lot of the things we want you to be thinking about prior to that August 29th date. So what's on our to-do list? Well, it's to review and update the contract terms, including any supplementary conditions, forms, and schedules. You're going to review and update your procurement documents, tender calls, proposal submissions. You're going to review and adjust your financing arrangements if that's applicable to you. You're going to update your invoicing, receipt, processing, and payment processes, including how you're going to deal with the partial payment and the apportionment of payments. You're going to update your certification process and make sure that you can get everything done within the prompt payment timelines. And you're going to ensure that those timelines are known by everybody in the company, all your administrative, your project management, and really anyone who's part of the execution process, to make sure that they are all being followed and adhered to. Because if you're not getting the notices out in time, you may be required to pay for amounts you dispute. You're going to figure out a method of electronic posting and have a backup if BuildWorks isn't ready. You're going to adjust your payment timelines and tickler systems to deal with the new holdback and varying lien periods. And you're going to make sure that your project management systems are in place and you're prepared and ready to go for the new prompt payment and legislation and the adjudication process thereof. So Carrie, did you want to say anything at the end here?
I think we invite questions even after the fact. We're going to be collecting questions. As I said, there were a couple of really good questions today that we'll include in our updated FAQs that we circulate throughout the industry and share other people's questions from other sectors in the industry. I want to say thank you to Dan for accommodating us and allowing us to present to the members. And hopefully that is an overview. There's lots more details. It's a bit overwhelming, but at least now we know what's coming and we can start getting prepared for it. So thank you, Dan, and thanks to the members. And to Jordan and Tom, thanks a lot, guys.
Yeah, thank you very much. Carrie, Tom, Jordan, very much appreciate you taking the time for the presentation today. And Carrie, as you noted, if folks have questions after the fact, feel free to reach out to me, and I'll be in touch with Carrie, Tom, and Jordan. And more to come on this. As noted, we'll be sending out some documents and information. And yeah, thanks everyone for your time, and enjoy the rest of your day. We'll be in touch soon.
Thanks, everyone.
Thanks.